Okay, good morning and welcome to a session of oral arguments of the 5th District Court of Appeal. Let me go ahead and start off by introducing the panel. As the Marshal mentioned, I'm Kerry Vander. Sitting to my right is Judge Bruce Jacobus, a former circuit judge in the 18th Circuit in Brevard County. And sitting to my left, we're very honored to have Judge Alan Swartz, who sitting as an associate judge today, sat many years as a judge on the 3rd District Court of Appeal. We do have 3 civil cases scheduled for oral argument today. Each side will be allotted 20 minutes. When the appellant comes up here, if you tell me how much time you want to reserve for rebuttal, I'll try to help you out in that regard. Also, if you have any cell phones, if you turn them off now so that we make sure oral arguments are not interrupted with. After our second oral argument, we're going to take a short break and invite the attorneys to join us in the attorney lounge for coffee. So, we understand if you have one of the first 2 cases and your schedule prevents you from visiting, we understand that, but if you'd like to, we certainly enjoy meeting you. All right, the first case will be BILBREY versus State Farm.
Good morning. Please the court. Pat Gilligan for the appellant, Elizabeth BILBREY. And I'd ask the court to remind me around 5 minutes, please. This is a uncontested liability UM case. The plaintiff and her husband were involved in a high-speed T-bone style collision. State Farm admitted liability on the UM portion of the case. The plaintiff, Miss Elizabeth BILBREY, claimed 3 distinct categories of injuries. Her first category injuries were she had neurological injuries comprising of dizziness, increased migraines. She had pre-existing migraines. She had balance or vertigo problems and sleep disturbance. She also had some orthopedic injuries, and those were primarily cervical and thoracic soft tissue issues with a pre-existing overlay, and she had some radiculopathy with that. And finally, her third category of injuries, she had scarring to her chest and breast from the seatbelt from the accident, and she also had lumps in her left breast. The first and third categories, the neurological injuries and the scarring and the bumps in her left breast, that evidence was completely unrefuted at trial. The only refuted evidence at trial was in the orthopedic category. And in that category, Ms. BILBREY was treated by a neurologist, Dr. Singh. Dr. Singh had treated her previously and after the accident, and he discussed her aggravation of her pre-existing conditions. He testified by video deposition at trial. The defense, State Farm, called Dr. Wadgi Ferris, who's an orthopedic surgeon in Ocala, and Dr. Ferris testified and explicitly made clear he was only testifying and rendering expert opinions concerning the orthopedic injuries. He basically stated he believed she had a pre-existing condition. He seems to imply from his testimony that that pre-existing condition was permanent. It was temporarily aggravated, and as a result of the aggravation, she needed some treatment for some period of time, but eventually she returned to baseline. But at trial, and specifically asked, do you have an opinion about the neurological injuries discussed by Dr. Singh? He said he deferred to Dr. Singh on that issue, and he had no opinions about the scarring or the lumps in her left breast.
Was there any type of neurological injury that the plaintiff had not received some type of treatment for prior to the accident in question?
I only believe it'd be the balance issues, Your Honor. I think the other ones, and perhaps the dizziness. I know she had the pre-existing migraines, and I know she had pre-existing, because of the migraines, sleep disturbance. I think the vertigo type dizziness and the balance dizziness, I think, was a new complaint. As a result, at the end of the trial, both the plaintiffs and the defense case, the plaintiff moved for a directed verdict on the issue of permanency, and that motion was denied. That's one of the issues before the court today. The second issue what I want to talk about first, because I think it does segue back to the first one, was the issue of the directed verdict made by the defense, State Farm, at the close of the case, where they made a motion to preclude introduction of any evidence of plaintiff's need for future medical care concerning her injuries to her breast. The trial judge granted that motion, and as a consequence, the plaintiff's counsel, myself, was precluded at arguing on closing argument the significance of her injury because I couldn't argue that she required any future medical care. And of course, the defense argued that the injury was basically trivial because there was no future medical care. The scarring issue is important because the statute, in order to get past the threshold, requires in section 637.7322 significant and permanent scarring or, and it's the disjunctive or, disfigurement. We conceded in our brief that typically that's a question for the jury, but the case law seems to indicate it's not all times, anywhere, it goes to the jury. And when you actually look at the statutory dictate where it says significant and permanent scarring or disfigurement, and you actually marry it up with a case law, I read the case law as saying it's the jury question to determine whether these things cause disfigurement. But a directed verdict should have been granted on the permanent scarring issue because Dr. Fiala, who was a breast surgeon.
Wasn't there ample testimony that the scarring was trivial at best and perhaps non-existent? Wasn't the jury able to determine that that was the case?
The jury heard testimony from the plaintiff herself that it had faded over time. Dr. Fiala said the scarring was permanent because all scarring is permanent. It's a change in the tissue, that he could see it and that he could feel it, and it was a fairly significant length. We're all men. I presume we all have wives.
Didn't she herself say that the scar was a slight, light one that you can't really see? If you can't really see it, how can you contend that it's a permanent injury?
She did. Well, it's permanent because the doctor says it's permanent. It's the issue.
We all know that the expert testimony, specifically physicians' expert testimony, is not binding on the jury.
When it's completely unrefuted and unimpeached, Judge, I believe that it is.
Well, isn't it impeached in this case by her own testimony that you can't really see it?
I would say it's minimized when she says it's faded, but it's still a scar on her left breast.
It doesn't have to be a significant scar. I mean, isn't that what the statute says?
Permanent, it says significant. Statute says significant.
I mean, that's kind of an objective thing, not subjective.
I agree.
Yeah.
But one thing we did get is, I do believe we proved it was a permanent scar. It was permanent in that Dr. Fiala actually told her there was no treatment that would actually make the scar better. It would probably make it worse because the treatment itself sometimes will make it worse. But the other issue was the lumps in her breast. The lumps in her breast.
Get back to scarring for a second. Dr. Fiala, when did he see the scar in relation to the accident versus in relation to the date of the trial?
I want to say it was about 18 months, Judge, but you have to rely on the brief. But I think it was about 18 months post-accident, 18 months to 2 years perhaps post-accident. Dr. Fiala also said that he felt the lumps in her left breast, not in her right breast, which was consistent with where the seatbelt also had the scarring. He sent her to a general surgeon because he was concerned about it. The general surgeon, Dr. Passetti, reported back to him that after he had some radiology films done and compared with the previous radiology films, that she had a cyst of various sizes in her left breast. The radiologist then recommended to Dr. Passetti, the general surgeon, and he agreed that she should be followed for that expectantly going forward.
Was it established as a matter of law, which it had to be in order to justify a directed verdict, that these lumps, such as they were caused by the accident?
Dr. Passetti thought that they were, and if you read his, now he didn't testify, but his record was admitted to trial, and he said that he believed it was caused by that trauma. Dr. Fiala, who referred her to Dr. Passetti, said it was consistent with her complaints of the accident where the seatbelt hurt her.
Well, that doesn't carry the day, though, does it? That it's consistent. The jury
Well, that's the
would find that, you know, women have cysts in their breasts.
That's the
who
argument.
are not involved in an accident.
I got some sense there were two kinds of lumps. You know, one they thought might have been from a hematoma, which probably was from the accident, and others were maybe fibroids or, you know, something unrelated.
I think that's correct.
Yeah, there were some, so there might have been some that were caused by the accident, and others clearly weren't.
Right, and both of the doctors relied on the testimony by history of Ms. Bilbrey to their physicians that they did not exist prior to that accident.
These lumps disabling in any way.
No, but they wanted to follow them expectantly.
Strictly not asymptomatic, perhaps asymptomatic as well. But it really didn't make
the reason
any
they wanted
difference
to
except to this lady, perhaps.
The reason they wanted to follow it expectantly was because just because it's currently benign doesn't mean it's going to be benign forever, and you may not have
You would have a
developing problem.
You would have a tough row to hoe to establish if this became unbenign that the cancer was caused by the accident.
Well, I can only rely on the doctor's opinions, both the radiologist and Dr.
Was she inconsistent in her testimony about the headaches, for instance? At some point she said she didn't have them before, then she said she did, then she said she didn't. Wasn't there some inconsistent testimony from Ms. Bilbrey about her prior treatment?
I believe there may have only been an inconsistency about the numbers. I think she did testify she had pre-existing migraines.
But I got some sense, I think she may have said at one point she did, and then she said she did. Maybe her deposition testimony was different than her trial testimony.
It may well have been, Judge. I don't recall that.
And then there was something, did she say, well, the doctor's records are wrong about things?
She may have.
He always got, I mean, that's always a bad fallback, but, you know, the doctor didn't get it down right, you know, which they don't. I mean, it's not necessarily, you know, she might be right about that.
I always seem to know more about my client's case than sometimes they do when they're deposed. So I have no doubt that there was probably some inconsistency in her testimony. What was consistent was Dr. Singh treated her both before and after the accident for the migraines, which he made clear, and I think he said there was an exacerbation of the migraine condition, and that was unrefuted.
But isn't that mean? A lot of the testimony of the doctors is based on what the patient has told them about, you know, pain and so forth. So when that gets impeached in some manner, that kind of takes away from the unrefuted doctor's testimony about permanency. You know
on the neurological injuries?
Yeah.
If it was impeachment, I call it impeachment. I say it was mild inconsistencies. But I think the jury clearly knew she had migraines before and migraines after, and it seems to be an exacerbation.
I mean, I think the doctor's records indicate that.
Yes, sir. So mild inconsistency. I don't think it reaches the level of out and out slam dunk impeachment. But as to the lumps in the breast, if it's the physician's view that it may be benign now, but we need to do something to follow this expectantly. First, the radiologist says it twice in the reports. The general surgeon, who she's referred to by the breast doctor, says, you know, I agree with that. We need to do that.
Isn't the law that you have to establish a reasonable certainty of both incurrence of future medical expenses and their amount?
Yes, sir, that is.
It doesn't seem to me
that is the law.
That's true of either one of them.
Well, the jury can rely on the prior bills. They were consistent as to amount, and we know the timing of it. It's annual. The doctor and the radiologist both say, let's do this annual, and he says, follow it expectantly. I mean, his language itself is...
You may have gotten more than you were entitled to.
Well, the records were stipulated in, Your Honor. I think the appellee's complaint is, no doctor testified to that.
If the jury had returned an amount of less than the actual out-of-pockets, there would hardly be an appeal from that determination, would there?
They weren't given a chance to even consider the future medical.
If as to past medical, if they had found that there was less past medical than the amount out of pocket that you were claiming, That would be up to the jury, wouldn't it?
I agree that is. They weren't given the opportunity to. The judge directed the verdict on the future medicals, and I'm quoting from Dr. Passetti's records about this lump thing and the future treatment. He says we should not dismiss the presence of the lesion, but that we should follow it expectantly. I admit he's being what good doctors are going to be, a conservative, but he's saying we should not just dismiss it and we should take a look at it anyway. So you've got in the record, in evidence, 2 medical records from a radiologist and the general surgeon saying that's something we need to do. And the record's unrefuted that the lumps in her breast were not there prior to this accident. By history.
Well, it's unrefuted only because she testified to that.
Correct, but just because...
she testified to a lot of things that are certainly refuted.
Well, that particular piece of evidence was totally unrefuted by any history, any other medical records. And just because the plaintiff says it doesn't mean it can be totally dismissed. None of the doctors that saw her, and there was 3 of them, a radiologist, a general surgeon, and a breast surgeon,
well, what are we
none of them dismissed it.
Now we're talking about only the future medical. We're not talking about permanency, correct?
We're talking about, yes, sir. And if there's a cyst there that was not there before that, that required a referral to a general surgeon. How long
after the accident did the doctor see the lady?
I'd have to check the records, but it was shortly after Dr. Fiala saw her because he referred her back to the general surgeon.
Mr. Gilligan, you're approaching 5 minutes.
Okay, thank you.
May it please the Court, my name is Rhonda Bogus, and I have the privilege of representing State Farm Mutual Automobile Insurance Company, the defendant and appellee in this matter. Plaintiff spoke of 3 different categories: the dizziness with the bouts of vertigo and the sleep, and as Your Honors has pointed out, it was very clear evidence in the record that the plaintiff, in fact, had suffered from dizziness and sleep problems for which she had been prescribed medication prior to the accident. As to the balance and vertigo issue, in fact, her physician said when he was asked if the trauma caused the condition, he said that, quote, it can. This was not a reasonable degree of medical probability. More importantly, when she in fact did testify that his records were incorrect, and that's actually on page 168 of the record.
They were incorrect about the headaches, is that what it was?
It was actually, I think, in relation to her neck pain and the condition. She told the CME doctor, Dr. Ferris, that she had had a previous whiplash injury for which she'd had symptoms for 2 years.
Right.
In fact...
That was in 1991.
Yeah, it was like when she was a teenager. And in fact, a month before the accident, she had come to him complaining of migraines and sleep problems.
Right.
In fact, her medication at the time of trial was pretty much non-existent, but prior to the accident, she was on quite a bit of medication for both migraines and sleep problems. As to the scarring to the chest, in fact, there was no permanency. 20% of the permanency, by the way, was for the dizziness and the sleep, which was pre-existing. 6% of the permanency rating was for the thoracic and the cervical. We had testimony, as he has conceded, that was totally inconsistent expert testimony on that issue. On the scarring in the chest and the lumps, she did say that she believed that the cyst and the lumpiness in her breast was new to the accident. Dr. Fiala saw her in January 2007. The accident was in November 2005. So we're talking about history only based upon a patient whose accuracy has been disputed. But more importantly, when they did the ultrasound and the mammogram in 2007, they found what were cysts and what could have been a hematoma. There were 4 different things that they found. In fact, Dr. Fiala testified that the lumps, quote, may be related to hematoma and some may just be incidental. That's on page 16 of his deposition. Incidental means they just happened to be found. I mean, she had dense breast tissue, she had cyst. There was a concern because of the hematoma to make sure that because of the size that it was not a neoplasm. That's where the watch expectancy came in. But that was in January of '07. She had the follow-up ultrasound prior to the trial. So she has the follow-up ultrasound. They said it's totally negative. The mammogram's negative. It's just a hematoma. There was absolutely no testimony anywhere, even in the medical records and certainly no live testimony, that would require any treatment at all. Dr. Passetti, in his 2007 report, did say as long as the lesion, he's speaking about what he thought may be the hematoma, remains stable or continues to resolve, I do not think any further evaluation is necessary. So he orders a 6-month follow-up, make sure that there's nothing, it's not growing, it's not a cancer. Certainly there's no indication that the auto accident would have caused cancer, but that was the follow-up exam pre-trial. What you're left at the time of trial, the trial was in November 2008. The mammograms and the ultrasounds were in April 2008. We're a negative mammogram. It says no mammographic abnormality identified, benign findings, routine screening recommended. Ultrasound's done. Ultrasound, no recommendation. We're talking about no connection between it all, that there was any type of further up evaluation that was going to be needed to be done on her breast. As was also pointed out, however, there was also no testimony as if there was further evaluation. Was this 1 year? Was this 6 months? Was this over a period of 5 years? What was the cost of that? None of that was presented to the court. Now in the briefs, the appellants argue that we're limited to just arguing because the trial judge found that there was no testimony leaking breast cyst or breast injuries to the accident, that is where the inquiry ends, and that we're not allowed to argue anything else. But what we're talking about is a judgment that was entered by the circuit court, which comes to this court with a presumption of correctness, and
An appellee who comes to the appellate court clothed only with the presumption of correctness catches pneumonia.
well, in this case, there's numerous reasons for it to be affirmed.
That's really a throw-in, isn't it?
Excuse me?
It's a throw-in. It's a presumption of correctness unless it isn't correct.
That is true, but in this case, in other words, Your Honor can totally disagree with the trial court and say, we think there's causation here. I don't think there is. But you can still uphold the judgment.
These are directed verdict issues.
Exactly.
They're both reviewed de novo.
Exactly.
If we disagree with the trial court, we reverse it.
Exactly. But if you agree that the trial court made the right ruling, even if you have a different reason, you also should affirm it. You have equal ability to review this record and see that not only was there really nothing establishing that the cyst, it's still the cyst issue, there are 3 cysts that were found in the 2007 ultrasound. We're down to only one of those was still there in 2008, and there was no testimony at all that they were anything other than an incidental cyst. You don't have any permanency relating to any breast injury, and you certainly has no testimony talking about why she would need a routine follow-up mammogram, whether that's the case in every single mammogram that's done, whether it's the case in anyone who's had breast implants, whether it's the case of anyone who's had breast tissue, which is what the report said. We don't know. That testimony was not presented. It certainly does not rise to the level of reasonable certainty. And I would respectfully submit, I did want to bring to your Honor's attention, there is a case that is before the Florida Supreme Court that's kind of dealing with the issue of whether a directive verdict can be entered based upon uncontradicted expert testimony. I did want to make sure you were aware of that. There's not been a ruling on that case, and I don't know whether, in fact, that they will issue an opinion. It's the Granger-Wald matter. But either way, whether the ruling is you have to have that it's always a jury issue, or whether the issue is there must be a reasonable basis of evidence in order to contradict an expert testimony, we have that in this case. We have the poor historian of the plaintiff. We have her disagreeing with her own doctor's records. We have her condition, in fact, better than it was prior to the accident, certainly according to prescription medication. We have conflicting expert testimony regarding specifically as to permanency. So it was totally appropriate for the jury to make the determination whether there's a permanent injury. The trial court appropriately submitted it to the jury, and unfortunately the plaintiffs did not get what they wanted, but that's the nature of jury verdicts. Same thing with future medical expenses. The case law is just legion that we do not allow juries to speculate as to medical expenses for which it's not reasonably certain that they're necessary, that they're caused by the accident, by a condition caused by the accident, the frequency as well as the cost. And so we respectfully submit that you affirm this matter. Thank you.
Thank you.
And, with your permission, I'd like to focus back on the breast injury. The causal chain starts with a plaintiff who's in a severe accident which causes scarring that a doctor sees on her left breast, and he feels in that left breast lumps that she says to her doctors and under oath did not exist prior to that accident. That same doctor says he examined her right breast, that there were no lumps in the right breast. So the case law cited in our brief says that when a condition happens immediately upon the onset of the accident, it's fundamental that one came with the other. Assuming that those lumps are in her breast, especially the one even at the 2008 of the second mammogram that's 5 centimeters by 9 centimeters that did not appear to have decreased in size at all, I suspect that's the hematoma. And that's the injury that the radiologist and the general surgeon want to follow expectantly, and both say she should have these annual ultrasounds and mammograms. And Dr. Fiala connects that by saying the reason you do both is because one test may pick up something that the other doesn't. And in fact, with Ms. BILBREY, that's exactly what happened. The mammogram doesn't show the cyst, the ultrasound does, and he says you do them in combination with each other to find that. This is a lady that, as a result of this accident, now appears by the evidence that's unrefuted, a hematoma in her left breast that's 5 by 9, that doesn't appear to be getting smaller, and her physicians, being cautious, want her seen annually to make sure that doesn't change. And that evidence we were not allowed to show to the jury and to argue the jury that it had changed her and that she needed this future medical care. And that's to me, the most important fundamental error of the trial court. This was a directed verdict. There was evidence there that a reasonable jury could have inferred that she needed that future medical care. That decision was taken out of the hands of the jury by the trial judge, and that's what we think is the fundamental error that should be reviewed de novo and reversed by this court. Thank you.
Thank you.